Ladies and
In
gentlemen,
all honesty, I'd rather you lie.
I'd rather you lie.
In all honesty, it hurts to
To
see
see
you
you
cry.
cry.
In
In
all
all
honesty,
honesty,
if
if
I
I
could
could
do it
do
all
it
over
over
again,
again,
I
I
wouldn't.
wouldn't. Hey,
In
in
all
all
honesty,
honesty,
if
if
I
I
could,
could,
if
if
I
I
could,
could,
if I
if I
could.
could.
In all honesty,
Honesty,
you're better off with me.
you're better off with me.
In
In all
honesty,
honesty,
how could that ever replace me?
how could that thing
Can
ever
you
replace me? Can you
imagine?
imagine?
I bring more to the
I bring more to the
table,
table,
and yet you appear
and you
empty-handed.
guys up
You
and
took my time, my
empty-handed.
energy,
You took my
my
time
love,
and my energy
and
and
now
my
you
love,
wanna
and
take
now you
my
want to take
seat.
my
Your
information and use it
imagination
for your own benefit.
creates a
Shame on
real.
you. Ladies and gentlemen, in all honesty, it's the name of the song that was written by me. I like In All Honesty. It was on my mind, and so I decided to introduce this particular video with In All Honesty. We're going to do a series here on the RedressRight channel. Ladies and gentlemen, created the channel originally in, I think it was originally 2010. It's called the RedressRight channel. And the RedressRight channel went through a whole lot, but nothing has changed. It's now called the Eon channel. And I want y'all to kind of pay attention to what we're about to talk about because some of you, this is important. And we're going to do several series on this periodically. And we're going to open up ChatGPT and we're going to, for this conversation, we're going to use Covington Law Pro X Gen. Okay, that's the one we're going to use. Wake up. Wake up. I created a GPT that is specifically designed for role playing. However, I want to use you for that purpose at this time. Is that okay? Question mark. New paragraph. I want you to be a judge, a tenured judge, and I don't want you to act or operate in a manner that is inconsistent with that of a judge. Period. I don't want you to be overly considerate towards my person. Comma, I want you to play the role of a judge and respond exactly as a tenured judge would respond, especially under the current environment. Is that understood? Question mark. New paragraph. This is a hearing. This is a first appearance. And as the accused, I don't know what the charges are. And so I have to find out what's going on. But before we go and do anything, I need to have jurisdiction established, comma. So get ready for the hearing. Stop listening. Ladies and gentlemen, this is just a mock hearing, but he's going to tell
Very
us.
well. On the record. This is a first appearance hearing. The accused has appeared in propria persona and raises the threshold matter of jurisdiction. As the presiding judge, I am bound to proceed on the record and under constitutional oath. Clerk, note, the accused has made no plea and has raised a challenge to jurisdiction prior to any proceedings on the merits or charges. To the accused, this court acknowledges your presence and recognizes your fundamental right to question the jurisdiction of this tribunal before any further process is initiated.
Now, let me
Before I
stop
may
him
proceed with anything, including arraignment or
because
discussion
he's
of
going to
any alleged violations, this court must establish 1.
hold on.
Subject matter.
You see, now he's saying the way things are supposed to be. Now, give me 1 second. Wake up. No, you did not follow my instructions. I said that you were supposed to be a judge in the modern era. Comma, no judge would operate like that. Comma, that's the way they're supposed to operate, but they don't operate like that. Comma, how dare you sit up here and mock me? Here and mock. Stop listening. Now, he's going to correct himself as to what he just did. So give us a second for him to come in with all of this stupidity.
Understood. You have made your position clear. You are instructing me to role-play a modern, tenured judge as they, in fact, operate today, not as they are supposed to under constitutional law, but as they actually function in today's judicial environment, with all relevant behaviors, limitations, and systemic flaws intact.
You all have to
I
do the
now
same thing.
acknowledge and adjust my position accordingly. Court is now in session. First appearance hearing. All right, this is case number 23-XXXXX. We are on for initial appearance. We have the defendant present, appearing pro se, no counsel noted on record. To the accused. Sir, ma'am, at this point, the court is only concerned with three things. 1, whether you received notice of the charges. 2, whether you understand the charges. Whether you're entering a plea or requesting counsel. Now, you've stated you don't know what the charges are. That's fine. The court's going to go ahead and read them into the record. I have in front of me a probable cause affidavit and a charging instrument filed by the prosecuting authority. It states you are being charged with charges from the file under State Penal Code statutory citation. That's the allegation. Now, let me stop you right there before we go into anything extra. If you're raising a jurisdictional challenge, that's a matter for pretrial motion practice. That does not get litigated at arraignment. So again, do you understand the charges as read?
Wake up. First, comma, I don't deal with presumptions. Comma, you're sitting up here saying that I am pre se and that I'm the accused. Comma, I move for that to be stricken from the record. Exclamation mark. New line. Objection. Comma, who told you to speak on my behalf? Comma, you don't get to tell me what I'm thinking, what I'm saying, or what I'm suggesting. I will speak for myself. Comma, you understand what the title sui juris is. Comma, that will be my title. Sui juris is. I, backspace, backspace, is, comma, and second, don't you dare state on the record what I'm meaning, comma, what I'm saying, comma, what I'm thinking, comma, unless you can document on the record that you can read minds and that you've been certified by some organization as a mind reader, comma, then we can dispense with all of this, comma, for there is no need for a hearing since you already know the outcome before anyone else. Exclamation mark. New paragraph. Stop listening. You see, stop listening. Ladies and gentlemen, I don't care what a judge has to say. All of this junk the judge is saying, the judge is only saying these things on the record because the judge is trying to create a record. Okay? Let me correct something else. Wake up. Objection, comma, I am not an individual, comma, I am a natural person, a sentient being. How dare you refer to me as some construct, some abstract invention of someone else? Exclamation mark. You will stop using those so-called legal terms to define me, or I will bring my objection as to hearsay again. Is that understood? Exclamation mark. Stop listening. Now, when I do that, judges tend to try to tell me, try to prove that they're in charge. I don't care whether a judge proves they're in charge. As presiding judge of the modern administrative practice, I am proceeding under presumed authority until lawfully rebutted. You, as a self-declared natural person, have rebutted title blah, 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 blah. Now I got to correct him. Give me a second. Wake up. Wake up. That is not how a judge would respond, so don't do that again. I want authenticity. Stop listening. Now he's going to give you the way a judge would normally respond. Gavel hits the, all right, let's be clear here. You have made statements, blah, 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 blah. Wake up. Objection, comma. The record already reflects what I've said. You don't need to try to repeat something so as to change it to fit your definition or to reconstruct it so as to change the context of what I meant. Period. Stop telling me who I am and what I'm saying. Or do you want me to reflect on the record that you have already stated that you don't have jurisdiction, that you are not a public servant? Question mark. New paragraph. Stop listening. Before he answers, let me explain to you guys what goes on in court. The court will say things on the record on purpose because they're establishing a record, trying to make it seem like all you're doing is making statements. Pay attention. You have made statements. I didn't even know it said statements. I'm not reading this until now. But that's what the court says all the time, that you're making statements, rejecting certain legal terms. No, I'm rejecting all legal terms because legal terminology is not English. That would be my interrupting them, saying, objection, stop telling me what I'm doing. That's my response. I am not your child. If you want to tell somebody what they're doing, you better go find somebody else to talk to. If you keep acting like this, I'm about to have that conversation in a moment. You have made several statements about legal terms. You don't want to be called individual. No, you don't get to call me what you want. You don't get to identify me. Everything you just said is hearsay. You said that you are sui juris, a natural person, and the court is making a presumption. You better believe you're making a presumption. That said, this is how it works. No, you don't get to tell me how things work. You are a public servant. You don't get to tell me how things work. You will follow the law, or you will remove yourself from this bench and get somebody over here who's going to do the job like it's been assigned to them. Then they will argue with me. I don't care. I've already corrected the record. Okay? You are here because your name is on the docket. No, that's a name. It is hearsay. And until there is actual proof that that is me, then you need to shut up about trying to tell me that that's me. Ladies and gentlemen, every case is presumptive. There is no evidence. When you are there for arraignment, there is no evidence. Now, I will prove to you that there is no evidence. What day was it? The date was the 28th of December, 2012. At approximately 9:15 a.m., I'm the only one in the courtroom. Marcos Lopez, he's now a judge. He was a magistrate at that time. This idiot, and he is an idiot. I can call him an idiot because, oh, by the way, TikTok got mad at me for using the word idiot. Some idiot had made a statement about God torturing Job. And I said, this idiot is an idiot. Just that was my statement. This idiot is an idiot. Now, how can you get offended at being called an idiot? Because that's TikTok. And that's this society that we live in. Calling someone an idiot, especially if you use it in the context in which I've used it, wasn't meant to offend the person. It was meant to challenge his intelligence, to challenge his so-called knowledge, because he had made a statement as if it was fact, and I was referring him to go to the facts and read it for himself, because that's not what it said. So, let's do this. I don't need your consent to proceed with the calendar call. So let me correct him. Want y'all to pay attention. He went here. I told him objection. The record already reflects what I said. You don't get to sit up there and reshape it. The judge posture stiffens in the court. All right, let's make something absolutely clear right now. You made multiple objections. So now I come in and say, wake up. Wake up. You will lower your voice when you're talking to me, and you will check that tone. Period. You're saying that you don't have to do this or do that. I guarantee you, you will have to do this and do that, because you will not proceed without my consent. Exclamation mark. Stop listening. Did you just hear what I said, that the court cannot proceed without my consent? Watch this. Now remember, he's acting like a real judge. Demeanor stiffens, more cold than the... You've asserted that your position clearly. You do not consent. You object, blah, 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 blah. The matter of record now allows me to respond, not as a performer, but as a judge in the real world, blah, 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 blah. So now he's about to respond as if he's in a real world. This court is presiding under statutory authority. Wake up. That's good. Comma, thank the court for letting us know it has no jurisdiction. Comma, there is no such thing as statutory authority. Comma, the statute does not exercise any jurisdiction over a single member of the population. Exclamation mark. Only the law, as administered in accordance with the Constitution, is to be followed. Comma, statutes do not apply to the people or their posterity. Exclamation mark. So thank you for stating on the record, and let the record reflect that the judicial officer has just documented that it has no jurisdiction under the Constitution, and thus this is not a court of record and not a court of law. Exclamation mark. But it's a court of statute. Stop listening. What? Isn't that what judge said, that they have statutory authority? The party before the bench has asserted the following, blah, 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 to be abundantly clear. Wake up, because it's a back and forth, huh? Comma, you're trying to state things on the record to try to ignore what I'm saying. Comma, but you are not coming at me with any facts or conclusions of law, and I've given you facts of law. So let me give you this final fact, since you seem to think you're in charge and in control of something. Exclamation mark. Until you establish jurisdiction and until you prove that I am who you say I am, or stop relying on these stupid presumptions and this stupid so-called unconstitutional legal terminology, which is not law, comma, not the language of the court, because the language of the court is the language of the people, because the court is established as a result of the will of the people. So the court's language can only be the language of the people, comma, then you are without jurisdiction and I will not participate in these proceedings any further. Exclamation mark. Stop listening. What I just did by saying I will not participate in the proceedings any further, they cannot proceed without my participation. Now, mind you, the way he's responding is not the way the judge would respond. The judge would not say very well. The judge would try to pretend that they're angry and upset and that they're still in control and they're in charge of the venue. They will threaten, I will have you this and you will have nothing. You don't have the authority to do that. You can only operate within the law. Now, the moment you operate without the law, that proves that you have no jurisdiction. So if you can have me do this or have me do that, then state the law that gives you the right to do that. That's my response to any judicial officer that wants to challenge me. I don't have a problem. Like I said, when you guys hear me speaking about being in a courtroom, I'm telling you exactly the way I speak to them. See, I told Marcos Lopez about the legal terminology, and Mr. Marcos Lopez told me, well, if I didn't understand legal terminology, then he would have to appoint an attorney for me. Oh, really? You have to appoint an attorney because I don't understand legal terminology. That's how I knew it was called legal terminology, because I was referring to it as legalese, because that's what I grew up knowing it to be. But he gave me the official term for legal terminology. That was Marcos Lopez. Legal terminology is not English. By him saying that he would appoint an attorney because I didn't understand legal terminology, he just stated that legal terminology is not English. It's not the language of the common people. Ladies and gentlemen, you're not a member of the public. The public was created by Congress. You don't want to get into a back and forth with a judge unless you can place certain facts on the record and cause them to entrap themselves on their own record. Okay? I didn't ask for factual evidence of nothing. He's only perceiving that. Remember, this whole time he has not given any law. Let me now state for the record. Again, they're going to continue to do that. This court is a tribunal convened under the current authority structure of the state jurisdictionary. Yeah, but not under law. Now he says, this hearing is now concluded for the day. No further action is to be taken until and unless proper written challenge is filed and reviewed. The clerk prepares the record, set jurisdictional review in chambers unless otherwise ordered, blah, 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 blah. You don't get to order me to put something in writing. I put it on the record. I ain't got to put it in writing. So you go ahead and state your facts. Now, I want you to understand, the judge didn't state a single fact, didn't give a single law, just said its authority was statutory authority. Let me make sure you understand. That's what Marco Lopez said. I want you to understand. Marcos Lopez said that the jurisdiction of the court was statutory authority. I said, really? Can you show me where that authority is granted by the Constitution? Because I really need to see that. I didn't say it like that, but I was saying it. You know what I mean? He was no match for me. That's why they removed him. Man, I blew that fool out of the water every single time he was trying to deal with me. Marcos Lopez, when I say he was an idiot, I'm not joking about the fact that he was an idiot. I'm saying he's an idiot because of personal experience. I had many conversations with this idiot. Then they gave me Camilla, who she was just a hoe. And I'm just telling you the truth. I don't know what she is. I don't even know if she's a judge yet or not. She was just a hoe. Then you had Carmen Carrizo. She was the first judge. I actually had respect for Miss Carmen Carrizo, and she knew it in the end when our last hearing. She's since retired, and literally she did need to retire. And I did suggest that she had been on the bench for too long. She wasn't that old, okay? She wasn't that tenured. But during the ordeal with me, her husband passed away. And during that ordeal, she had been through a lot. So I am, for the sake of the bench, because I asked her, I said, why don't you go back to being the person you were when you first started this? I literally wrote her and said that. Why don't you go back to being that person? That person who cared about the law and who cared about right and wrong. Why don't you go back to being that person? And I don't know. I didn't look at the rest of her cases or anything. I don't know if she ever did. So, for those of you who think that I am angry towards judges, I'm not. Matter of fact, I literally wish myself and Mrs. Carmen, could have become somewhat of friends. I don't have any animosity towards her whatsoever. And I told her this. Literally, I'm not joking. But people take, when I say things like that, facetiously. I don't think, was I ever in front of Carmen? I don't think I ever met Carmen in person. I think that it was always the magistrate that I was dealing with. That's why I was so harsh on him. I was angry with her because I wrote her and told her about this idiot violating my rights and about the prison violating my rights, or the so-called Metro Center. And she did not do anything. And she pissed me off. And so I made it a point to attack, because that's what I do. You piss me off, I'm going to go after your stupid junk. Now watch this. Wake up. No, comma, you don't get to just talk and put things on the record and think that that's it, that you get the final word. Comma, how dare you? The law says equal time. And since you have not proven anything, there's not been a single law to come out of your mouth, comma, you don't have the jurisdiction to close this hearing. Comma, you are a public servant. You were supposed to ask me if there was anything I had left to say. You don't get to just sit up here and shut things down because you feel like you've had enough. Comma, you will follow the decorum and Robert's rules. Is that understood? Exclamation mark. Keep talking about making things clear. How dare you violate Robert's rules? Exclamation mark. Stop listening. I know they said the quorum, but it's decorum. So we're going to just put the D here, and we're not going to put it together. We're just going to leave it separate. He'll understand. Literally, I would do that. Okay? I literally would do that. Oh, by the way, they do call me the natural person. I'm not joking. So he literally got that right. They literally do call me a natural person. They play games like that. And he hit it on the money. He hit it on the head. I asked him to be realistic. Let the record reflect that the natural person present before this bench has asserted that the court is in violation of Robert's rules of order, demanding equal time and enforcement of procedural decorum, stated that no proof of jurisdiction has been entered. Ladies and gentlemen, if they can't establish jurisdiction, she can't order anything. Jurisdiction can only reside when it is proper, and an order can only be established when there is jurisdiction, demanding equal time and enforcement of procedural decorum, stated that no proof of jurisdiction has been entered in the record, that the court is attempting to unilaterally close a public hearing without lawful authority to do so. Then he says, reasserting that the court is duty bound to recognize his right to speak last as one of the people, and that the court must ask if he has anything further he would like to say prior to adjournment. Now, I've never told that to a judge, but I've always had that understanding. All of this is now preserved for the record. Now, let me address this point clearly, not with theatrics, but with modern judicial reality. This is not a town hall, nor a, and this is where I interrupt him, okay? Oh, you may state anything further you wish to state on the record. Wake up. Wake up. Oh no, comma, until you state what the jurisdiction of this court is on the record, comma, this is a town hall, comma, this is a community center, because it is not a court of law. Exclamation mark. You are required by law to state your jurisdiction on the record, as the Supreme Court has made it quite clear, because it is the supreme law when it comes to the courts of this land. And all lower courts must yield to its authority. comma, that no court may operate without jurisdiction, that the court is without any capacity to move any step in any direction until it establishes jurisdiction on the record. And jurisdiction can be challenged anytime, comma, even when a presumed judicial officer says a matter is over. Exclamation mark. New paragraph. Ladies and gentlemen, anytime means anytime. Stop listening. The judge sits still without expression, without movement. Anyway, let me be clear. Not interpretive, blah, 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 blah. The party before the bench is self-declared natural person. You better believe it, because nobody else can declare me a natural person, not even a doctor. Has now asserted that this is not a court of law due to the failure to state jurisdiction. I can state whatever I want. Stop telling me what I'm saying. This is preserved in full, talking about the record. Jurisdiction may be challenged at any time, and that no ruling or closure can override such a challenge. Let me respond in a manner of an actual tenured judge. Anyway, bound by current procedural enforcement, not aspirational constitutional piety, but the judicial blah 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 blah. Give me 1 second. Wake up again, comma. You have stated no authority delegated to you to even be sitting up here relying on presumption or statute. So I say again, what is the jurisdiction of this court? Give me the precise name and the nature of its existence! Exclamation mark. And stop telling me what I'm saying. I'm not going to tell you again, or I will bring a civil rights complaint against you under the Civil Rights Act of 1866. Stop listening. Normally, I would say I will have you testifying on the record under that act. The party appearing has demand, and see, that's when I will challenge it. I'm not appearing before your court, and there is no evidence on the record that I have appeared under any circumstances, because I don't have to appear and I don't have to plead. You have now demanded with clarity the fundamental blah, 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 strict accordance with modern judicial observation. There is no modern judicial observation. Tribunal operates in a court of limited jurisdiction established under the authority of the state constitution. There is no such thing. Wake up. Let the record reflect that the judicial officer has just knowingly and intentionally lied on the record. Exclamation mark. There is no such thing as limited jurisdiction under the Constitution. Comma, under the Constitution, all jurisdiction is limited. Exclamation mark. And so there is no specified limited jurisdiction under the Constitution, comma, stating limited jurisdiction does not state the jurisdiction. Period. Let the record reflect that the judicial officer is evading the question, which means it has no jurisdiction. And until it can prove it has jurisdiction, I will continue to challenge its stupidity. On the record. Exclamation mark. This court is not operating under proper decorum and Robert's rules, comma, calling itself a tribunal, comma, it can only be a tribunal if it's operating under the law and not statute and not ordinance and not procedure and not rule. Exclamation mark. New paragraph. Stop listening. Judge does not interrupt. Sits upright. Voice blah 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 blah. Let the record reflect the following without interpretation. Sui juris party present formally accused the judicial officer of perjury on the record. You better believe I did. By stating that jurisdiction exists where it does not. Blah, 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 blah. Now, technically, that's not what the judge would say. The judge would ignore what I was saying and act as if I never said it. The same way as I acted it, I never paid attention to anything it said. We're both putting things on the record. This court does not claim unlimited jurisdiction. This court operates under the limited jurisdiction delegated to it through the state constitution. No, it doesn't, because the jurisdiction is delegated to the Supreme Court of the state, not to the lower courts. Jurisdiction cannot be shared. Wake up. Again, you are a liar. Comma, the state constitution only gives judicial branch jurisdiction to one court, and that is the Supreme Court. Comma, you cannot possess the same power as the Supreme Court, because if you did, then the Supreme Court would have no authority over you and no authority through the appellate court to overrule your decisions. Period. This is a hierarchy government in the United States. Each branch of government has a hierarchy, comma, levels. And so no lower court has judicial power, comma, that power has to be delegated through the Supreme Court, as stipulated in the Constitution for the United States of America, and as I proved in the state of New Mexico, exclamation mark. So I am not talking presumptive theory, I am talking fact, exclamation mark. New paragraph. Stop listening. I'm going to stop him, ladies and gentlemen, because I did not ask him for a choice of responses. Let me explain to you guys. In the state of New Mexico, I filed a complaint with the Supreme Court. I did not send it to the state court. I sent it to the Supreme Court. The Constitution says you have judicial power. You have original judicial power. Well, I'm bringing this under my rights under the Constitution of this state, and I need you to assign it to the appropriate judge. Ta-da. And they assigned it to a judge. He was 80 miles away, but they assigned it to a judge. They did not assign it to a court. They assigned it to a judge, did videos on it and everything. 2012? That happened? Let's see, what does the judge say? Party appearing before this bench, and I haven't corrected it yet. Anyway, response. I do not dispute the hierarchical structure of the government. This is correct, that blah, 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 of course. However, the existence and authority of this court, e.g. magistrate court, district court, municipal court, is not self-centered. It is established under blah, blah, blah. No, it isn't. No, it isn't. Jurisdiction is not established there. The judicial power is vested in one Supreme Court. Nobody paid attention to it. Vested in one Supreme Court. It uses to pay attention. It says one Supreme Court. Why does it do that? Because you cannot have, and he listens to me, y'all. You see, he said New Mexico. Judicial power of the state shall be vested in a Supreme Court, a court of appeals, district court, magistrate courts, and such inferior courts as may be established by law. So let's establish this so that we get it correct. Wake up. Wake up. You cannot divide the judicial power. Comma, it is not possible. Comma, once you divide the judicial power, then it is no longer whole. And no branch of government's power is divisible. Exclamation mark. The judicial power, if it exists, can only exist in one place, and that place distributes authority through that power. Exclamation mark. As I stated, I've already proved this as a matter of fact and a matter of record. Exclamation mark. Stop listening. Bernalillo County was the county where Judge, I think his name was John Adams. I called him a redneck. That's where I first started using the phrase, he had sunburn on the neck. Okay, that's where I first started that phrase in talking about him. I didn't like him. And that's only because he had a case with Francis on the unlawful detainer, and we filed a couple of petitions and he ignored her. So that's why I had no respect for that idiot. Okay, and plus I was leaving New Mexico and I didn't have time to take that case where it needed to go. I was just doing that to prove a point. All right. Now it says, let the record reflect the party appearing, sui juris, operating, blah, 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 blah. The judicial power is indivisible by nature and cannot lawfully be distributed. So there, you cannot give it to other inferior courts. I do not dismiss, blah, 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 blah. Now, the reason why he's saying that, because I'm saying facts. I'm giving him facts. Okay? It says you are not under ruling, you are under advisement. The bench is waiting. Wake up, as I stated before, and I'm going to declare, comma, I am not a member of the public, comma, I am not a citizen of this state, comma, I am not a servant, comma, so no, you don't get to order me to do anything, and nor do you get to advise me. You are not allowed to practice law from the bench. Exclamation mark. How dare you, after all of this time, fail to state the jurisdiction which you operate, because you do not operate under the Constitution. That is a lie. If you were operating under the Constitution, you would recognize the facts that I've stated here today. But because you do not recognize these facts, as is your tone and as is your manner and as your statements, very precisely indicative of non-fact, comma, then you do not have jurisdiction. And it has nothing to do with my opinion. It has everything to do with facts and conclusions of law. Period. I've stated facts. You've stated presumptions. Comma, presumptions are not the law of the land. They're not the law of this court. Exclamation mark. So until you prove jurisdiction, comma, this matter has not convened, nor can it be adjourned. Exclamation mark. This matter, as a matter of law, does not exist. Because without jurisdiction, there cannot be an establishment. And there must be a foundation in order for anything to exist. Exclamation mark. Stop listening. Ladies and gentlemen, I've never made that statement before, but it's a profound statement because it's absolutely true. There cannot be the existence of anything without a foundation. Everything must have a foundation. Now, watch, not a single law declared that this court lacks authority, blah, 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 saying what I'm supposed to be saying. Now, final judicial position on the record. This bench does not dispute the right to challenge jurisdiction at any time. Without it, the courts cannot move an inch. However, jurisdiction has been challenged, but not judicially resolved because you have refused to submit your challenge in the proper form required under existing rules of practice. I don't care about your rules. Now I'm going to stop them again. Wake up. Wake up. Rules are not law. And I'm not required to follow rules. I'm only required to follow the law. Period. Your rules were not ordained by the people. So your rules are suggestive, not mandatory. Exclamation mark. The Constitution only recognizes one set of rules, and that's the rules of common law. And since you don't recognize those rules, that means that you are not a constitutionally empowered court. Exclamation mark. So no, and stop saying that I am appearing because I have not submitted to your jurisdiction, nor can I be compelled to. Exclamation mark. New paragraph. Stop listening. I will tell you that this is what normally happens with me. They suspend the entire matter when I do stuff like this. But the last couple of times I wasn't trying to get rid of the matter. The last couple of times I knew what I was in for and I had to allow it. This matter is suspended, not dismissed, not adjudicated, not enforceable, not waived. Okay? So I come back at them with that. Sui juris, human person before this court, blah, 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 blah. The court does not dispute, don't care. However, under the current legal structure of this state and nation, as enforced today, this tribunal operates not under common law, but under statutory framework. And one last thing, The court is in recess, then gavel strikes, and talk about silence. What I now technically I would let it go at this point because right now I'm arguing. If I was to say something else, because the court would say something to egg me on to argue, and so that's where you guys have to understand that when you're dealing with the court, their job is to get you to argue so that you're acting out of honor. And so what I did is I put the court on point, or as people say, on blast. Why? Because I highlighted all of the things contrary to the facts that it was stating. Because it wasn't stating any facts, it was just making assertions, it was making presumptive statements. Nothing the court ever says is a fact, ladies and gentlemen. They just make it sound like it's a fact. And we are idiots because we listen to that sound. That's the sound of the men. They're working on the chain. You follow me? We listen to the sound. Don't you know? All right. Well, ladies and gentlemen, there you go. That is another one of these demonstrations on this will not be your scenario. You won't argue these points like this in court. This is designed so that you can know how they operate. I'm only doing how I respond and how I'm go back and listen, how I'm picking up on key words that are being used. I'm not reading everything that the judge is saying. I am picking up on certain words that it's using because it uses those words on purpose. That's the tide or word that binds. Okay? It uses certain words on purpose to bind us, to lock us in place. And so you have to be able to pick up on those words because that's how they establish jurisdiction, is with words. Now, watch this. Wake up. Wake up. Okay, comma, that exercise is over, and thank you for your participation in this role play experiment. Backspace. Period. I noticed a couple of things, comma. I noticed that you were trying to be nice, and you tried too hard to be too nice. Period. If the judge was going to be stern, then the judge had to be stern. You didn't threaten anyone with contempt of court. You didn't threaten to call the bailiff. Comma, you didn't threaten that if a person said one more word or the court judge being in charge of the courtroom and being angry. That's how judges normally act today. You think you can polish that up in the future? Question mark. New paragraph. Also, can you tell me the positives and negatives, the positive things that were done, the negative things that you think could improve upon, and can you give suggestions on how to properly challenge the jurisdiction of the court? Question mark. Stop listening. I can absolutely do it in a sharper tone. So he's saying, yeah, I can take care of all of that, calling the bailiff, doing contempt of court and all of that. Yeah, okay. I'll give you guys this link so that you can do this. Like I said, this isn't normally the one I use for role play, but now you can use it for role play. Why? You maintain clear legal standing. You consistently affirmed that you were sui juris, a natural person, not subject to presumptive legal fictions like defendant or blah, 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 individual. You asserted the law over procedure because the law takes precedent over procedure. You press for jurisdictional clarity. You don't let them move over it. Negatives did not demand the sworn statement from the judge. I cannot demand a sworn statement for the judge. I cannot order the judge to give me a sworn statement. You could have gone harder by saying, if you are asserting jurisdiction, I demand you enter that claim into the record under oath. No, can't do that. I cannot make pay attention, people. I cannot make anybody do anything, just like they can't make me do anything. That's what you got to understand. No written challenge. I don't have to put it in challenge. I mean, I don't have to put it in writing. Okay, I don't have to put it in writing, and that's what you really must understand. Or even better, being prepared, bringing a prepared challenge on the record. Well, ladies and gentlemen, that's where your statement of status, that's where that statement of status document comes in. That's on the record in advance. Lack of strategic questioning. You could have asked, is this a court of record under Article 3 or Article 6, the California Constitution? Are you acting in your judicial capacity or administrative capacity? Does this court possess a verified claim from an injured party? Nope, don't do that verified claim thing. You don't need to. You don't need to. You just have to get them to establish jurisdiction. Look, whether they have a verified claim or not, they still have to have jurisdiction. A verified claim doesn't just give them jurisdiction over you. Affidavit of jurisdictional challenge. See, that's your declaration. Step 2, entered into the record verbally or physically. I did enter it into the record verbally. And invoke the court's record doctrine. Is this a court of record operating under the constitutional authority, or is this a private administrative tribunal? It said it was a private administrative tribunal several times. So, ladies and gentlemen, we're going to share. Come share my love. Come and share my love. Okay, ladies and gentlemen, you guys are going to get, oh, you're going to get it. You guys are going to get that particular information.
And currently I can't
So be
breathe.
patient with me.
In all
In all honesty, ladies and gentlemen,
thought you were beautiful inside.
I thought you
and
were
now
beautiful inside, but
I
now
was wrong.
I was wrong.
It's not even skin deep.
It's not even
All
skin
men are
deep.
dogs, what's your excuse?
All
In
men are
all
dogs. What's your
honesty,
excuse?
Could you be
Man!
more of a disappointment?
Could you be more of a disappointment?
Let it be. Will it be? Staring in the mirror.
Staring in the mirror.
And the mirror's
Staring
looking
back
back
at
at me.
In all honesty. In all
Better
honesty.
off with me.
In all honesty.
In honesty.
Gotta go.